Welcome to an examination of Colorado and federal law regarding transgender and gender nonconforming students and employees in public schools. I'm Pam Benigno, and I'm the director of the Education Policy Center at the Independence Institute. We're a free market think tank located in Denver, Colorado. You can find us at independenceinstitute.org, or a simple way is just to remember thinkfreedom.org. The purpose of the meeting tonight is to educate all of us, including myself, about really new concepts that we are not used to. New transgender laws that are changing things at public schools. And so after several people have asked me questions, I thought it would be appropriate to ask Eric Hall, an attorney who has done trainings on this issue before, to come and explain to us about the laws, because we have to remember that public schools have to follow the law. But this meeting will equip you so that you can see, is your school or school district following the law, or are they going beyond the law? And then you will be empowered to go to your school board or to the school district's attorney and ask questions. Mr. Hall can only answer a limited number of questions tonight, which you can put in the Q&A, not the chat, the Q&A. But he will later not be able to analyze your policies. And I'm not an attorney, so I won't be able to either. However, you're welcome to email me at pam@i2i.org. I do want to tell you that on our website, independenceinstitute.org, you can find education pages with lots of wonderful education papers that we use to educate the public and policymakers about laws and policy. And one of our newest papers is called Curriculum Transparency, a must for effective parent-teacher partnerships. And I encourage everybody to read that paper, and it'll help you understand a little bit more about curriculum transparency and how school districts work, how they adopt curriculum, and so forth. And there's some good policy recommendations in there as well. So I would like to introduce now Mr. Eric Hall from Sparks Wilson. He's an attorney in Colorado Springs. And Eric, I'm going to let you take it away now.
All right. Well, Pam, thank you very much. I am very pleased to be here with all of you on this webinar. I have been an attorney for 22 years, and in that time, I've represented lots of schools, public and private, universities as well. In public schools, I've represented charter schools, which again are public schools, school districts, and then other educational entities. And this issue of transgender legal rights has really come to the fore, especially in the last year to 2 years. We've been getting lots of questions here at the law firm on what are exactly the rights of transgender students and employees and the rights of other people in the schools. So that's what we're going to cover tonight, and I've prepared a PowerPoint presentation that I'm going to share with everybody now. This presentation I've made available to Pam and the Independence Institute, and so if anyone wants it, they can get it from Pam, and it'll probably be on their website. So let me share my screen so that we can, let's see. Oh, Pam, little technical issue. It's saying I can't share my screen. So can you allow me to do that?
Yes.
And then again, let me just say a couple other things. I have tried to condense this talk within the hour that we have, which means I'm going to cover as much ground as I can. I won't be able to cover absolutely everything, but I will cover as much as I can on, again, transgender rights, both under federal law and state law, focusing mostly on Colorado law, because that's where we live, and that because we have detailed regulations here in Colorado, as you will see. But I know I will leave some things out, and by necessity, I've had to, really summarize a lot of what the law is in some of these areas. Okay, so let me share that. And now let me So again, here's my titles page. And again, I just want to thank the Education Policy Center at the Independence Institute for sponsoring this webinar. And I want to start with description of a case, Gavin Grimm versus Gloucester County School Board. You can see I've given the citation up there. It's from the Fourth Circuit. It's a Virginia case, and Virginia's in the Fourth Circuit. And the reason I give you the citation, and I'll give you a lot of citations, is so that later, if you want to look up any of these cases, you can just Google them, and they'll allow you to get right to where you want to go to actually see the law or the case that I've been discussing. And again, you can get this PowerPoint later from Pam at Independence Institute. And also, talking about the Gavin Grimm case is also helpful because it illustrates so many of the principles that we're going to talk about later. And so I'll also use it as a fact pattern when we're discussing the legal rules in Colorado. So starting to move through it, the court in the Grimm case said at the outset, at the very beginning of its analysis, this quote, "To be sure, many of us carry heavy baggage into any discussion of gender and sex." I agree with that. I know that is for myself and for other folks I've given this presentation to. And so from whatever standpoint you're coming from, my goal here is just to do the best I can to tell you what the law is, and then tell you where it's clear and where it's unclear. And I'll do the best I can trying to answer some of the questions that reside maybe a little bit in the gray area. And then hopefully by the end of it, regardless of, again, what baggage any of us might carry into this discussion, we know a little bit more. So factual background. Gavin Grimm was born female. As a ninth grader, she enrolled as a female student in Gloucester High School in Gloucester County, Virginia. That's where Gloucester County is, and that's Gloucester High School. You can see the little Google dot there, maybe 30 to 45 minutes east of Richmond in Virginia. In April 2014, at the end of Grimm's freshman year, she told her mother that she was a transgender boy, because again, she enrolled as a freshman in the high school as a girl, but then at the end of that, she told her mother she was a transgender boy. In August of 2014, at the beginning of his sophomore year, Grimm and his mom told the school counselor he was a transgender boy. Now you'll notice I switched my pronouns there, and I did that on purpose because, again, as you'll find it with Colorado law, one thing the law says in Colorado is it is sexual harassment, it is sexual orientation harassment, which includes transgender harassment, to not use the pronoun of the transgender person's choice. And so once Gavin Grimm decided he wanted to be called by the pronoun he, I'm going to try and do that here. So when he decided in his sophomore year, told the school counselor he was a transgender boy, the bathroom situation, which was a key part of this case, was this. There were boys' bathrooms, girls' bathrooms, faculty bathrooms, nurses' bathrooms. For boys and girls, it was multiple users at a time. For faculty, a single person would use the bathroom, and then the nurse's office also had a single user bathroom. Why is that important? Because at the beginning of his sophomore year, Gavin agreed to use the single user bathroom in the nurse's office. However, once school started, he found it stigmatizing to use a separate restroom, and also using the nurse's bathroom caused him to be late to classes given where it was located in the school building. The school permitted him to complete his PE classes online, so he never had to use the locker rooms. Again, why do I bring up this fact? Because again, locker rooms are another facility where people dress and undress, students dress and undress. That wasn't an issue here because the school said you can do your PE classes online. For 7 weeks, Grimm used the boys' bathroom without any incidents, but then people heard about the fact that he was a biological girl, transgender boy, and students and adults complained to district leadership. There was a board meeting, I believe in December of 2014, and most of the comments in that board meeting, as the court recites in its case, centered on these two ideas, that the majority must be protected from minority intrusion. Specifically, parents were saying, you know, Gavin Grimm is a transgender boy, but there's a majority of cisgender, i.e. people whose gender conforms with their biological sex, and the majority has got to be protected, right? Why are the minority rights winning here is what a lot of the comments from the parents were at this board meeting. And second, parents also said allowing transgender bathroom use would permit predatory behavior by transgender girls. Again, these are biological boys who are transgender girls. And parents were concerned that these biological boys, transgender girls, would be able to use the girls' bathroom. So that's where most of the comments came. In December 2014, after that board meeting, the board member passed a policy saying bathrooms and locker rooms can only be used by those of the biological gender only that they conform to. Transgender students would be given alternate private facilities. So that was the board's policy, their decision. Gavin Grimm then sued under the Equal Protection Clause and Title IX. After 5 years of litigation, very hard fought litigation, a lot of people submitted amicus briefs in this case. It was very well known in the legal communities. After 5 years, he won on equal protection and Title IX grounds. I'm not going to go into the reasoning of the court because that would take us too far afield of what we're trying to do today, focusing primarily on Colorado law. All right, switching gears, I want to talk about federal law briefly, and then Colorado law in some depth. All right, federal law. Here's the landscape for federal law as it might apply with, again, transgender legal rights for schools. We have the Equal Protection Clause, which again applies to public schools, not private schools, but public schools, saying you can't deny government, including public schools, can't deny someone equal protection of the laws. As these cases, like the Grimm case, have held, cases brought under the Equal Protection Clause, the courts have tended to, almost unanimously, when these transgender cases have gone up to the circuit courts, held that there is a denial of equal protection if you don't allow a transgender student to use, for instance, the bathroom or the locker room that is consistent with their gender identity. Statutorily, federal law, we have Title VII. Again, Title VII governs the workplace, i.e. employees, and it prohibits workplace discrimination on a number of different grounds, including sex. And then many of you might know that in 2020, June of 2020, big US Supreme Court case, Bostock versus Clayton County, where the US Supreme Court majority held that the Title VII prohibition on discrimination basis of sex includes a prohibition on the basis of sexual orientation and transgender status. So Supreme Court holds that in Bostock in June of 2020, which then means that for all employers subject to Title VII, which would include public schools, you can't discriminate on the basis of sexual orientation or transgender status because of Title VII, because of federal law. All right, that's as to employees. What about us as students? Well, Title IX of the Education Amendments Act has a similar protection. If an entity receives public money, then they're bound by Title IX. All public schools that I know of receive federal money, and so therefore they're bound by Title IX. The language I have there on the screen, you can't be deprived of an educational benefit on the basis of sex. And since in Bostock, the Supreme Court held that sex includes sexual orientation, transgender status, then the Department of Education said in August of 2020, well, in light of the Bostock decision, then we now believe Title IX should be read to say that you can't discriminate against students on the basis of sexual orientation or transgender status as well. And again, the cases, the circuit court cases around the country that have addressed this issue have agreed with that interpretation. That's federal law. I could talk a whole lot more about federal law, but again, we don't have time to go into that. And I think Colorado law is more illustrative because it gives us a whole lot more detail. So moving to Colorado law, the relevant law is the Colorado Anti-Discrimination Act. And a little bit of history on point here. In 2007, the Colorado legislature added sexual orientation, which included transgender status, as a legally protected class under the Anti-Discrimination Act. Again, I encourage you to look up Senate Bill 07025, which took effect August 8th, 2007, where you can see how the Colorado legislature added sexual orientation. And so that meant, again, as of 2007, as of August 8th, 2007, both employers and entities subject to public accommodations laws, which I'll talk to you about in just a second, which for purposes of this webinar means public schools, couldn't discriminate on basis of sexual orientation and transgender status. So this has been the law in Colorado for a long time. This isn't new law. This is actually fairly well-established law in Colorado. All right, here are the provisions, the specific provisions, and again, I encourage you to look up the citations if you want to. As to employees, again, Colorado employers, including public schools, can't discriminate on the basis of sexual orientation, gender identity, gender expression, and similarly, students have the same protections because public schools are places of public accommodations. So, quick note, public accommodations are those places where the public can go to get services, like hotels, like restaurants. Again, think of the civil rights movement and the civil rights laws back in the 1960s when the issue was racial discrimination. The same sort of idea applies here, but since Colorado added sexual orientation, transgender status as a protected class, then public accommodations like public schools can't discriminate on that basis either. What about private schools? Thought a lot of you might have this question, so I added a slide. Secular schools are subject to the Colorado Anti-Discrimination Act because they are public accommodations. In fact, Anti-Discrimination Act, the section here, 6011, says that all educational institutions are public accommodations and therefore subject to these rules. However, private religious schools are not subject to the Anti-Discrimination Act for two reasons. One, because the act itself carves them out. It says any religious schools that are principally used for religious purposes, or actually any entities that are principally used for religious purposes, any accommodations, are not subject to the public accommodations section and therefore the Anti-Discrimination Act. There's a little caveat here. If a religious school is supported in whole or in part by public funding, public taxations, or public borrowing, then I believe the employment provisions of the Anti-Discrimination Act would apply. So if you're a religious school, or if your children attend a religious school, or if you're on a board of a religious school, you might ask, does our religious school accept any public funding? Are we supported in whole or part by public funding? Because if you are, then you might, the employment provisions might apply to you. And again, you can look at those citations and read them for yourself. All right, so back to the public school context. Oh, I'm sorry. One more note. Religious schools also have protection under the First Amendment. So I've listed two Supreme Court cases from 2020, 2012, Our Lady of Guadalupe, Hosanna Tabor. These cases hold squarely that the First Amendment bars courts from entertaining employment discrimination claims brought by teachers. So that would mean, again, the Anti-Discrimination Act is a discrimination statute, and these cases say that the First Amendment would say that the First Amendment trumps the Colorado Anti-Discrimination Act if it was trying to be applied against them as to sexual orientation or transgender status. Okay, now moving back to public schools. The rest of my talk will deal with public schools. Here's the definition of gender identity in the act that this section was actually, the act was updated in 2021, which is why I have the year there. And again, what gender identity means. It means an individual's innate sense of the individual's own gender, which may or may not correspond with the individual's sex assigned at birth. So gender identity, the individual's innate sense of that person's own gender. Gender expression, again, how you express your gender to the outside world through appearance, dress, or other behavior. Transgender, note The transgender definition is located in the regulations, not in the statute itself. That's what CCR means, Colorado Code of Regulations. You can see where it is located. Transgender means having a gender identity or gender expression that differs from societal expectations based on the gender assigned at birth. Okay, so in 2007, like I mentioned, the Colorado legislature amended the Anti-Discrimination Act. In 2008, a year later, the Colorado Civil Rights Commission adopted sexual orientation harassment regulations. And these are the things that are, they have the force of law in Colorado, and they're the detailed regulations that address the primary questions in this area. So that's why it's most fruitful here in Colorado to discuss these regulations specifically, because they spell out with some specificity exactly what's required. So we're going to talk about those now. All right, so first, the sexual orientation definition under the regulations is this person's orientation towards heterosexuality, homosexuality, bisexuality, or transgender status, or another person's perception. The last part could be important. All right, I'm going to spend a little bit of time here because unlawful harassment is defined under the regulations in this way. This definition of unlawful harassment is important because it sets a higher bar than most people might expect. Unlawful harassment isn't just anything that happens that a transgender person might dislike or be subjected to, but rather unlawful harassment is severe or pervasive conduct that creates an environment that is subjectively and objectively hostile, intimidating, or offensive on the basis of sexual orientation, again, which includes transgender status. All right, what words are important there? First, severe or pervasive. So again, like I said, it's not just any old conduct that matters. It has to be severe or pervasive. And courts have held that that's a sliding scale. So one really, really bad, really offensive, really scary bit of conduct could qualify. It could be so severe. Or if it's just a whole lot of conduct, all offensive, unwelcome, but not so awfully bad. Okay, well then it's got to add up to be pervasive. It's pervasive in the school, such that what? It creates an environment that is subjectively in the law means it's offensive and unwelcome to the person who's being subjected to it. So in the Gavin Grimm case, to Gavin himself. It's offensive and unwelcome to him, but also not just subjectively, also it has to be objectively hostile, intimidating, or offensive. Objectively in the law means what a reasonable person would consider hostile, intimidating, or offensive. So you have to have all those components, severe or pervasive conduct that is subjectively and objectively hostile, intimidating, or offensive on the basis of sexual orientation or transgender status. Okay. Now the regulations go on and they get, again, more specific. We have to keep in mind what I just finished talking about as we kind of tick through each one of these. And we're going to expand a little bit on each one. Okay, first thing, sexual orientation and harassment includes asking unwelcome personal questions about an individual's sexual orientation or transgender status. So we could all, think of some unwelcome personal questions, which someone like Gavin Grimm would find offensive and would, go to a counselor, go to a teacher, go to the principal and say, I don't want to be subjected to this. I shouldn't have to be subjected to this in my public school. Whether it's teachers or students asking me questions about, when I became transgender or why I became transgender, or is there something in my family history about my sexual orientation, or any of those sorts of unwelcome personal questions. So that's one area. Second, intentionally causing distress to an individual by disclosing to others the individual's sexual orientation. This is often called outing, right? Intentionally causing distress by outing the transgender person to someone else. Okay, so notice first, again, these regulations, again, I invite you to look them up after the webinar, but these are the words of the regulation. So this is the law that we have, and it's intentionally causing distress by disclosing to others. So again, if you accidentally do it, if you didn't mean to do it, then it wouldn't constitute harassment. How do you determine those things? Well, it's going to be very fact-based. Ultimately, it's going to be a jury question. Schools don't want to get into that. Schools want to make sure that all the students that come to their schools are able to come and learn and feel welcome and not feel harassed or bullied. And this is, again, one of the things that therefore schools need to be aware of. They shouldn't cause distress to a transgender individual by disclosing to others the individual sexual orientation. We're going to talk a little bit later about who the others are that you can't disclose to, because this is all we have. It doesn't explain who those others might be. But let's keep going. Using offensive names or terminology regarding an individual's sexual orientation. This one is fairly easy legally, just because for public schools, you're not going to tolerate anyone using offensive names or terminology about anything, let alone transgender status or sexual orientation. If a school, if someone, one student is calling someone else an offensive name, a school's going to want to put a stop to that. Or likewise, coworker to coworker, or whatever, adult to student, student to adult, doesn't matter. Using offensive names, illegal, must be stopped by the school. Next one, deliberately misusing an individual's preferred name, form of address, or gender-related pronoun. So again, this is a regulation. This is the Colorado regulation, often called misgendering, where this one gets a lot of press. A lot of people want to discuss about this. We're going to talk about it a little bit more. Note first that it's got to be deliberately misusing. So again, if you accidentally misuse it, okay, we understand that. If you repeatedly accidentally misuse it and say the school doesn't do anything about it, then all right, then I think any judge or jury is going to start wondering, well, how hard are you really working to follow the law here by using someone's preferred name, form of address, or gender-related pronoun? We're going to come back and talk more about this later, so I'll keep moving for now. The last regulation is this one, harassing someone because of communications related to the individual's gender expression. So this one was added recently to the regulations because I don't know why. I'm surmising that the Colorado Civil Rights Commission also wanted to protect people talking about, again, their transgender status or their gender expression, or lobbying the school, and they don't want to then be harassed because they're saying to a school, hey, we need protections, or do you know this is happening? So this protects the communications about gender expression, transgender status, or sexual orientation. So those are the detailed, some of the detailed regulations, some of the most important ones, which is why I spent some time on. All right. The regulations go on to say, if an individual thinks they're being harassed, then that individual must take advantage of any remedial measures made available by the public school, unless pursuing such a complaint would be futile. So if there are any public school administrators out there, you should certainly make sure you have remedial measures, i.e. you have some sort of grievance policy. You have a way for a student or a staff member to make a complaint so that the school will be aware of it and be able to take measures to stop whatever is going on. But now note, the end of that regulation says, if pursuing a complaint would be futile, then you don't have to go through those remedial measures. So the school wants to make sure that any of its regulations are responsive, and if you make a complaint, it actually gets heard and addressed. So, but you can't just go straight to court. You can't just go straight to the CCRD, the Colorado Civil Rights Division. You have to try and internally to the school make a complaint first. Okay. Next, the school must initiate an investigation and then take effective remedial action, i.e. you've got to investigate and then you got to stop it. If you realize that some illegal conduct is going on, then you need to put a stop to it. But that's effective remedial action. You can't turn a blind eye. You can't just pretend it's not happening or say, oh, boys will be boys, students will be students, they're only 10. You can't do that. You got to take effective action to stop it if it is going on. That's what the regulations say right here, Rule 81.6b. Okay, the regulations also address gender segregated facilities. So to begin with, let me say gender segregated facilities are permitted, i.e. you can have separate restrooms for boys and girls. They're not only permitted under the Colorado regulations, they're also permitted under Title IX. Those are the Title IX regulations, the Code of Federal Regulations. So this is, people should not misunderstand this to think, oh, we've got to get rid of boys' bathrooms and girls' bathrooms, or men's restrooms and women's restrooms. No, you don't have to do that. Facilities under these regulations include restrooms, locker rooms, dressing rooms, so think drama, and dormitories. So again, currently, maybe a high school has an acting program, and there's a dressing room for boys, there's a dressing room for girls, or maybe I know this applies in the higher ed context as well, if you have dormitories, or if you're a private secular school and you have dormitories at the K-12 level, then again, facilities includes these areas. Why does all this matter? Because again, public schools must allow the use of the gender segregated facilities that are consistent with their gender identity. So again, going back to the Gavin Grimm case, Gavin was a transgender boy. If he went to school in Colorado, under these Colorado regulations, he would be entitled to use the boys' restroom, or the boys' locker room, or the boys' dressing room if he was in a play, or in boys' dormitories. This can be extended to, I know some public schools maybe have camping trips, or maybe they go on trips to Washington, D.C. And there you might say, okay, we're going to have, divide up the students in the hotel and have the boys stay with the boys and the girls stay with the girls. Okay, this rule would apply in that context as well. So Gavin Grimm, as a transgender boy, would stay with another boy in that context. Okay, keep going. Now, the wording here is important. And when I've talked to many of my school clients, we've talked about the shall allow language, because the regulation says public schools shall allow individuals the use of gender segregated facilities consistent with their gender identity. It doesn't say the transgender students must use the gender segregated facilities, but rather that the schools must allow them to. So I have had some cases where I've talked with, not formal litigated cases, but just clients calling me, where they describe the situation. I say, okay, well, you need to sit down with the student and the student's parents, and again, I'll get to the parents in just a second, and talk about, well, does this, again, let's use Gavin Grimm again. Gavin Grimm's transgender boy, does he want to use the boys' restrooms? Because he has a legal right to use the boys' restrooms, but he doesn't have to. He could use the girls' restrooms. He must be allowed to use the boys' restrooms, but he could continue using the girls' restrooms if he wanted. And I know some students in situations with some of my clients have made that choice. Or like Gavin decided early on, he could continue to use a single-use restroom, like a nurse's restroom or a faculty restroom. But again, the Colorado regulations say public schools must allow them to choose. Now, I've given this this presentation a number of times. At this point, some people will ask, well, can they switch back and forth? Can they go, boys' restroom on Monday and girls' restroom on Tuesday? I'll first say I've never actually encountered that situation. In all of the real life situations I've dealt with as a school attorney, talking with schools about transgender students, and again, the last year to 2 years, I've had a lot of questions on this issue. I've never had a student, or a teacher for that matter, a transgender teacher, want to do that. They've always wanted to, once they've decided, okay, like Gavin did, in 10th grade, I'm a transgender boy, then they've consistently wanted to use the same restroom once they kind of had thought through it. The regulations don't answer the question of whether a person wants to go back and forth. The court cases also that I've seen don't answer the question about gender fluid or people who don't identify as either gender and want to use both. If that came up, then again, the courts would have to deal with it and we'd have to interpret the regulations. But So far, again, I've never, while I can easily conceive of those questions, I've never had to deal with them head on. And I don't think either the regulations or court cases address them directly. Okay, another important regulation in Colorado. When there are gender segregated facilities, again, think of boys' locker rooms, girls' locker rooms in the gym. All right, and there's undressing, like you have with, say, high school sports, right? Then public schools must make reasonable accommodations to allow access consistent with the individual's gender identity. So again, Gavin Grimm, let's say he wanted to participate in a sport, transgender boy, he's going to use the boys' locker rooms. Then the school must make reasonable accommodations to allow access. What might those be? Well, the easy ones that courts talk about are, well, let's say you have a whole bank full of showers. Well, putting up curtains so that rather than everybody showering together, you've got curtains where both Gavin might choose to shower inside the curtain, or putting up like more single area stalls, or maybe curtains in the actual dressing area, so that people feel more comfortable as they are dressing and undressing. Again, prior presentations, people ask, well, what happens if you're, again, behind the curtain, and then you, like Gavin Grimm, finishes undressing, and then he walks out, right? And he walks through the boys' locker room with the other boys. Yeah, well, what courts have said is people need to get used to that. And that's not as concerning as some people would like to say, is the way courts have addressed that question. We'll talk a little bit more about that coming up. Okay, so how about a case from Colorado? The Coy Mathis case. You can see on the left, there are two restroom cases. One, the Adams School Board case from Florida, 11th Circuit. I'm not going to talk about that one, but it's just another one if you want to read it. It's right on point. But I do want to talk about the Coy Mathis case, because that happened here in Colorado Springs. Coy Mathis is biological boy, transgender girl. And when she was in, I think it was kindergarten, in a Fountain Fort Carson school, elementary school, her mom said that, again, she was a transgender girl and so wanted to use the girls' bathrooms. And I remember, because I'm a lawyer and interested in these things, do this sort of law, I kept up in the papers on this case, and I saw that the school district, Fountain Fort Carson School District, said, well, how about Coy use a single user bathroom? Again, nurse's bathroom, faculty bathroom, something like that. And the mom said, nope, she wants to use a girl's bathroom. I believe she has a legal right to do so. Fountain Fort Carson said, no, we would really want her to use a single user bathroom. And so the mom filed a Colorado Civil Rights Division complaint. That's what CCRD stands for there. CCRD charge number P, and then you can see all the numbers. And again, the Mathis family won. The Civil Rights Division found that probable cause that Fountain Fort Carson had discriminated against Coy Mathis by not letting her, as a transgender girl, use the girls' bathrooms rather than a single user bathroom. That case didn't go any farther. I think Fountain Fort Carson just stopped after that. I know the family, I think, moved to Denver at some point in that litigation, but as far as Colorado precedent, it's not binding legal precedent on courts, but it is precedent for the CCRD anyway. Okay, here's another case which people might be interested in. This is out of Pennsylvania, Doe versus Boyertown Area School District, cited in 2018. And the reason I find this case worth talking about is because the school district, in this case, the school district allowed the transgender students to use the restrooms and locker rooms consistent with their gender identity. Interestingly, for this school district, the case talks about how in I believe it was 2016, they rolled out this transgender policy, and they rolled it out and they said that a transgender student had to obtain approval, had to go to the counselors, had to say, yeah, again, pretend you're Gavin Grimm, you're going to a Boyertown school district, and you say, I want, as a sophomore, I'm a transgender boy. Okay, I want to get approval to use the boys' restrooms. You have to get approval from the school administration. But then the policy required, once approved, you could only use those facilities. So Gavin Grimm could only use, again, the boys' bathrooms, locker rooms, once he made that choice. Again, that's different from Colorado law, and that was the policy that the school district crafted itself. There was no indication in that case that Pennsylvania law was as detailed as Colorado law. So that was just the school district choosing to make a transgender policy like this. Okay, so that's the policy, important to know, because then the cisgender students, meaning the students whose gender corresponds with their biological sex, the cisgender students sued to enjoin the policy, i.e. to go to the courts and say, courts, you got to tell the school district not to move forward with this transgender policy, because, as the cisgender students said, this violates our constitutional rights to bodily privacy. And they also added things like Pennsylvania legal rights to bodily privacy. So again, the reason I add this case is because you can imagine cisgender students saying, well, what about our privacy? Again, we heard about that in the Grimm case, where the parents said, well, what about the majority of students? What about their privacy in bathrooms and locker rooms? And again, in this case, those students sued. They lost. They lost this case in the Third Circuit. And the reasons why, summarized very briefly, is the Third Circuit found that the transgender policy that the district had enacted advanced a compelling state interest, which was a least restricted means if you're a lawyer out there, in preventing discrimination against transgender students. So that was one of the reasons. And the second reason was the district provided enough private facilities for everyone. Again, Boyertown School District went to some lengths to make sure that there were a lot of single-user bathrooms, that there was privacy in locker rooms. For instance, they changed the showers in the locker rooms to give more privacy, et cetera. And that was important to the court, as they said, there's enough private facilities, not only for the cisgender students, but also for the transgender students. And so again, the court ruled against the cisgender students in that context. Okay, back to Colorado. Moving from Pennsylvania back to Colorado, let's talk a little bit more about names and pronouns. Again, I'm just reminding everybody that Colorado regulations says if you deliberately misuse a transgender person's preferred name, form of address, or gender-related pronoun, that could be sexual orientation harassment. What about religious objections? That's what we're going to talk about next. The Merriweather case. This is from the Sixth Circuit. Let me give you the facts of the Merriweather case. The conclusion here is that this university professor won his case when he objected on free speech and free exercise grounds to following the public university's transgender policy that required him to use the preferred pronouns of the transgender student in his class. Again, okay, that's the conclusion. Let me describe the case for you. The case was, again, university professor. That's important because university professors have more constitutional free speech rights than K-12 teachers. But university professor taught at a public university, also important because that meant Title IX, Equal Protection Clause applied to the university. Taught philosophy, taught there for 25 years, was a respected professor, also a deeply devout Christian. And there was a student in one of his classes who presented as a man, and the professor, the case relates how the professor, when he first called on him, said something like, yes, sir, or Mr. Smith, whatever it was, to him, but because he looked like a man. But then after class, the student came down to the professor and said, I am a transgender woman, and I demand that you use the pronouns of my choice. The professor said, I can't do that based on my religious rights, my exercise rights, based on my religious understanding. I can't do that. He tried to work with the university, and that's very important. Professor Merriweather tried to work with the university, and the compromise that he proposed was, can I just call this student by the student's last name? and the case just used a John Doe name. So the case talks about, can I just call him Doe, not Mr. Doe, or not, or not his preferred, name, whatever that was, but just Doe. And the university initially said, no, you can't, after a little bit of back and forth. But this professor won, both on free speech and on free exercise grounds. And it's the free exercise grounds that are especially important, because I think the analysis of the Sixth Circuit would translate to other parts of the country if, again, the 10th Circuit, which is where we are, adopted their reasoning. Here's another case from Virginia, Loudoun County School Board versus Cross. Here you had a school board that was proposing a transgender policy. A elementary school teacher, PE teacher, went to the school board meeting where the board was considering the transgender policy that was going to, again, require everyone, all the teachers, staff in the schools to use the pronouns of the transgender student's choice. And he objected. He said, I disagree with that on religious grounds. I disagree with it on philosophical grounds. I don't think it's good for kids if we do this. And so he gave a very short, probably within his 2-minute little speech to the school board. The next day, he was put on paid administrative leave, and he was said essentially, don't come back. What you said at the school board meeting yesterday is disruptive. He got lawyers, he sued, and he won. And this is the case from, again, the Virginia Supreme Court, where it said he won based upon free speech grounds and for exercise grounds, because the school couldn't censor his speech or punish him for his speech when he was raising an objection to this transgender policy at the right time in the right place. All right, we keep moving. Okay, disclosure. As I said before, sexual orientation and harassment, including disclosing to others. Well, who might those others be? Well, teachers and other school staff have a legitimate educational interest in the student's information. So I think, while it's not perfectly clear, this is a citation to FERPA, I think that a school can disclose to other teachers, like Gavin Grimm's teachers can know, and maybe others that deal with Gavin Grimm, just like more details about his situation. Again, not too many details, not unnecessary details. What does that mean? Well, again, I think at least, again, for Gavin Grimm's, his teachers, about just who he is, a little bit of a history, what he prefers, what bathrooms he might be using, etc. I think that would be legitimate. That would not be a violation, in my opinion, of the two others. What about parents? So there's a long line of constitutional cases going back for decades, gosh, almost 100 years now, which says that parents have the constitutional right to the upbringing and raising of their children. I give you a couple citations, but there are lots of other citations. My interpretation is that this means this constitutional right of parents for the upbringing of their children means that parents not only have a right to know about what their students, their children are thinking in this area, but they actually have the right to decide. So let's talk about that a little bit more. So parents and pronouns. What if the student doesn't want his parents to know? Again, what if Gavin said to his teacher, I don't want my parents to know? I think the line of cases about a parent's constitutional rights means that the school actually must tell the parents, even if the student doesn't want his parents to know. Again, I think you need to do that carefully. I think you need to do that thoughtfully. Again, I think if it was Gavin, I think you'd want to sit down with Gavin and explain all this to him and explain that you're going to need to tell his parents, just like you need to tell his parents if there were other important things in his life that the school found out about. Second thing, and again, I've dealt with these situations. What if the student and the parents disagree about what name and pronouns to use? Again, my belief is that line of constitutional cases I referred to means that the parents get to decide so long as the student is still a child. And children are, people 17 years old and younger. So again, if you have if Gavin Grimm is 17 years old, I still think his parents get to decide. If Gavin is 5 years old, or Coy Mathis. I think if the parents get to decide if there's a disagreement between the student and the parents. Okay, important note here. If the student, let's say Gavin Grimm, discloses to a school social worker, Colorado law says that a school social worker and other mental health providers can provide psychotherapy services, which I think would include talking about, the fact that they're transgender and working through those issues. If they're 12 years of age or older, can talk with a school social worker without the consent of the minor's parents. So this is kind of an exception to what I was just saying. But the school social worker needs to do two things. One, needs to decide that the student, the 12-year-old or older student, is knowingly and voluntarily seeking these services, and the provision of these services is clinically indicated and necessary to the minor's well-being. If the social worker makes those findings, then the social worker does not need to tell the parents. This statute goes on. I'm not going to go into all the details, but I thought it was worth flagging. I mean, one important area that it goes on to say is if the student tells the social worker that they're considering suicide, then the social worker is required to tell the parents. So again, there's some nuance in the statute, but I do think it's important for everybody to know here. Okay, athletics. This is the final topic, and then I'm going to take questions because I know we're getting towards the end. With athletics, I want to start with the baseline rule under the Colorado High School Activities Association, which is bylaw 2850.3. And this does not have to do with transgender, it's just the rule about boys and girls playing sports. If a school has separate teams, i.e. a boys soccer team and a girls soccer team, all right, well then if you're a boy, you have to play on the boys team. If you're a girl, you have to play on the girls team. Okay, that's the current CHSA rule. What happens if you have only a boys soccer team and the school doesn't have a girls soccer team? All right, well then the CHSA rule in that case is girls can try out to play on the boys team in that circumstance. And if the girl's good enough and she makes the team, well then she can play on the boys team. All right, flip it around. What if you only have a girls soccer team and you don't have a boys soccer team? Well, CHSA says boys cannot try out for the girls team. So those are the current CHSA bylaws, kind of generally speaking, when addressing boys and girls. Okay, now CHSA goes on. They have a specific transgender inclusion policy where the CHSA recognizes the right of transgender student athletes to participate in interscholastic activities free from unlawful discrimination. And then much of the rest of the policy just parrots the Anti-Discrimination Act and the regulations. So essentially, I think I interpret it to mean CHSA, the current CHSA policy is, again, if Gavin Grimm were to play sports in Colorado and he was a transgender boy, then he'd be able to play on the boys team, the boys soccer team, right? Even though he's biologically a girl. Or flip it around. Let's say, again, it's Coy Mathis. Coy Mathis grows up biological male, transgender female. She would be allowed to play on the girls soccer team, even though she's a biological boy, under CHSA's rules. That's the way I interpret them. Now, the implementation of these rules is that the student's home school must first perform a confidential evaluation to determine gender assignment. Also, the rules go on to say that the student athlete must have a consistent gender identification. So you can't have a person who wants to play boys soccer in the fall and girls soccer in the spring by saying, oh, I identify as a boy in the fall and I identify as a girl in the spring. CHSA's rules or regulations don't allow for that. Gender fluid students, they talk about have to select one gender in which to participate. And then if they then decide that they're a different gender, they must detransition. So again, if you had Gavin Grimm playing girls soccer his freshman year of high school, and then he identified as a boy, then under CHSA's rules, he could identify as a boy and play boys soccer so long as they go through these steps. That's a very high level overview, but that's where we'll have to leave it because I know I'm almost out of time and I do want to get to the questions and answers. So let me now stop that. Okay, so we're back. And let me now try to answer some of these questions. I know we just have a few more minutes, so I'll try and answer the questions that I can. And I know some people sent questions in advance. The first question that I believe Pam got and forwarded it to me was, can schools do more than is legally required? And this person was asking about some school district policies that did more than what Colorado required. My answer to that is yes. School districts can do more than what's required, but school districts need to recognize that there are competing legal interests. It's not just the interests of the transgender students. You also do need to consider other interests. The easy one is religious interests for religious students, religious faculty. And I've touched on some of those interests very briefly. And then also, I think the Bowertown School District case is illustrative because you can see there in Pennsylvania, that district had some nuance, some extra thought into what they wanted to do, and I think that's allowed. Next question. Are Colorado's transgender regulations unconstitutional compelled speech? First, I've not seen any court cases that deal with these cases in terms of unconstitutional compelled speech. I would doubt that a court would find these regulations requiring, again, people in public schools to use the pronoun of the transgender person's choice to be compelled speech, because in other contexts, in other discrimination contexts, everyone's speech is limited, and that's not considered unconstitutional speech. So you don't have a First Amendment right to use sexually harassing terms or racially harassing terms or religiously harassing terms. And so similarly, I can't imagine a court would say, oh, well, you do have some sort of legal right to use harassing terms for transgender. Again, the one big carve out here is religious speech. But again, I want to be real careful and say that the Meriwether case, it was important to that court. I think it would be important to any court that the person expressing a religious objection wanted to find a compromise that was as least offensive as possible. I've not seen any cases where the person says, my religious belief that I believe God created, people, men and women, and transgender is not in God's creation. And so I'm just, by goodness, going to call people Mr. Doe, Ms. Doe, he, she. Again, that's not what Professor Meriwether did. I think it served him well. We'll see if we ever get cases that go that step further. Next question. Is the transgender worldview a religion that cannot be established in public schools without violating the Establishment Clause? I don't think so. Sort of for the reason I explained earlier, I don't think courts would consider these transgender regulations to be a religious worldview, which would constitute establishment of religion. Yeah, I just don't see that happening. I certainly haven't seen any cases litigated along those lines. Next question that, again, we got in advance was a person asking about very young children, children 5, 6 years old. What about parents in schools, thinking through, well, is it good for a child, at age 5 and 6 do they even know what gender identity or pronoun usage means? Again, my view is that line of cases saying parents have a constitutional right to the upbringing of their children means that parents should be brought into that conversation, and parents have the last word in that conversation. But absolutely, I think parents and schools need to be age appropriate when thinking through these hard issues. Another question which we got in advance was, can schools have gender-specific uniforms? Yes, is the short answer to that. Under Colorado regulations, yes. Under the Colorado Anti-Discrimination Act, yes. You can still have a uniform for boys, a uniform for girls, a uniform for men, a uniform for women. I know some school districts and public schools, like charter schools, are moving away from those, but some schools still use them. And yes, that's still allowed. You're going to want to make sure that you think through those carefully. I'll give you a caution. Just a couple months ago, there was a case called Peltier versus Charter Day School in North Carolina, where a North Carolina charter school required all of their female students to wear skirts and dresses and not pants or shorts. Heavily litigated case. The charter school lost, and the girls that sued won on equal protection and Title IX grounds after a lot of decisions going up to the Fourth Circuit. So again, you don't have unlimited discretion, but you do have reasonable discretion in that area. Okay, so those, I see it's 8:01, Pam, and we're out of time, and I see we've got a whole lot of questions in the Q&A box, but maybe we're just gonna have to save that for another webinar.
Thank you, Eric. I was thinking the same thing, that we may need another webinar to answer those questions. You did an excellent job, and I appreciate it so much. And I know that everybody that was listening appreciated it as well. We are recording this meeting, and if you're interested in a recording, you can email me at pam@i2i.org. Give us a few days, maybe even a couple of weeks to figure all this out. And we'll probably post it to a page on our website with maybe some links. So I want to thank everybody for attending tonight. And again, Eric, thank you. Everyone, have a great night.
Yeah, thank you, Pam. Appreciate it. Thanks, everybody.
Bye-bye.